Welcome to the Maison Law Podcast.
Hello, everyone. Welcome back to the Maison Law Podcast with attorney Martin Gasparian, founder of Maison Law. Martin regularly helps injured Californians pursue compensation in cases where fault is disputed or shared between multiple parties. I'm Sean O'Connor, and today, Martin and I are discussing whether you can still recover compensation if you were partly responsible for an accident. Hello, Martin.
Good afternoon, Sean. Nice to be back.
Good to have you back. This idea of shared responsibility is interesting because it varies from state to state in terms of how this kind of thing gets handled. Can someone still recover compensation in California if they were partly responsible for an accident? How's that work?
Absolutely, Sean. And it is my true belief that it takes two to tango, right? So whenever you're involved in a collision and there's two vehicles involved, there's always fault that can be placed on both parties, a percentage that is, Sean. So even if you are partially at fault for the collision, under the comparative fault statute of California, you are still entitled to compensation for your injuries.
So, it's probably not just simple math, but I'm guessing that someone's saying, hey, Sean, you were about half responsible for this, and Martin, you were about half, and so literally it's just like, all right, 50-50. That's what happens.
So I could actually give you an example numerically, Sean. Let's say you deemed 40% at fault for a collision, right? And your settlement value is $100,000. What happens in that scenario is $40,000 is reduced from the $100,000, and your net total settlement value would then end up being $60,000 because of the apportionment of fault.
Got it. So that makes sense. Speak to me about comparative negligence, Martin. How does California's system work?
So California has a pure comparative negligence system in place, Sean. So what that means is even if you're more than 50% at fault, so let's say you're 75% at fault for the accident, you're still entitled to recover 25% apportionment for what you were not at fault for. So, for example, if your settlement value, if you were not at fault, would be at $100,000, you're still entitled to recover 25%, which would be $25,000 if you are placed 75% at fault.
Got it. And of course, now I want to know how the heck they determine who, each person's share of fault. What types of evidence are typically used to determine that?
Typically, police reports are taking a look at what witness statements have been provided, what pictures or videos there are from the scene of the accident. Those are the main drivers in terms of assessing liability in car accidents, Sean.
There seems to be so much footage. I mean, everybody's got a video camera in their pocket, right? But then also the cops are using dash cam, and cars have dash. Yeah. So I'm imagining all of that gets pulled into the case.
Absolutely, Sean. These days, especially with the growth of electric vehicles that have cameras on them, most electric vehicles that have cameras on them, you're able to tell fairly quickly in terms of how the accident happened.
What are some of the most common reasons insurance companies try to blame the injured person?
So any statement that you use, for example, right after the accident, you say, "Oh, I'm sorry, we were involved in this accident," even though you're not at fault for the accident. The insurance companies will use that statement against you by stating, "Well, you did apologize for the accident, so you must have believed that you were at fault for the accident." Or another common scenario that we always see is, "I must have not seen you." If the other driver ran the red light, and in that particular situation, the insurance company will most likely communicate that, well, you weren't properly paying attention to the road if you didn't see the person.
And what if I have a pre-existing condition? Because I've heard that, like, if if you already have a bad back, you're not going to be able to be compensated for, a back injury. Is that true?
That is not true, Sean, because even if you do have a pre-existing condition, your condition may have exacerbated as a result of the collision, and so you are taken as an actual plaintiff in the state of California. And if your injuries or your pain symptoms worsen as a result of the crash, you are still entitled to compensation, regardless of whether or not you have pre-existing back pain.
The talked about inadvertent, well, not inadvertent. I mean, the idea like, oh, I'm sorry, being construed as apologizing or admitting fault when that wasn't the case. Um, what if someone does actually, you know, admit fault at the scene of an accident? You might just, oh, sorry, that was my fault. What what can happen there? I'm imagining that's going to hurt my case. Yeah.
Even if you do communicate that you think that you're at fault, there are various other factors that may have gone into the collision. And so what our office does is we would go ahead and retain accident recon experts who would take a look at the weather conditions, the visibility, the road design, um, take a look at how fast the other vehicle was traveling, evaluate where the point of impacts are on the vehicles to assess whether or not you were truly at fault. Just because you think you're at fault, you may not be at fault for that accident.
That's true. That's a good point. There's a lot of other environmental things going on that I may not even have been aware of. So, what if there's another scenario? What if the police report places some or even all of the blame on a person?
The police report isn't admissible evidence in the state of California. It is considered a hearsay under the evidence code. And what that means is because the law enforcement officer wasn't there and did not actually witness the accident, their opinion of the accident doesn't matter. And so even if the law enforcement officer puts you at fault, their opinion doesn't matter to us. It's not admissible in court.
That's interesting. But I mean, the police report does go in as evidence, right? But it's not. It sounds to me like you're saying it's not necessarily the biggest uh, determinant.
What you are able to use from the police report is what they've actually tracked down in terms of what the weather conditions were, what the road conditions were, and any sort of statements that they've obtained from witnesses or from the drivers that are involved in the collision. But with respect to the opinion as to who they believe is at fault for the collision, that's not admissible evidence.
I know this is your business. You're focused on it all the time. Do you have an example of a case where, fault was disputed, but, the injured person was still able to recover compensation?
It happens all the time, Sean, where fault's disputed and there's still compensation for the injured party. And the most common example that I can give you is when a driver is making a left-hand turn and the third-party driver ends up running the red light and speeding, and the crash occurs. Police reports 9 times out of 10 end up putting the person making the left-hand turn at fault for these types of collisions. However, part of our job is to recover the evidence and the data to prove that the person was not at fault, and that we're able to do with cameras from nearby businesses. We're able to download the EDR data off the party who ran the red light, which shows how fast they were speeding at the time of the collision. And so we're able to reverse a liability decision that a police report may have placed you at fault for when there's additional data and evidence that comes into play.
Got it. Got it. For people listening out there, what would you want someone to know if they're hesitant to pursue a claim because they think, they may have contributed to the accident? So, what's your advice to them?
our advice would be, even if you believe you're at fault for the accident, you may not be at fault for the accident, and call and get an opinion from a professional. Have them evaluate the police report and have them take a look at the data before coming to that conclusion.
Interesting. Yeah. So, and as from what you've described too, Martin, and given the comparative negligence conversation we were having, so even if I think I'm at fault, there's still a good chance that, given the amount of evidence that you could acquire, that I may be somewhat at fault, but there'd still be some room in there for me to make a claim and be compensated.
That is correct, Sean. Even if you're placed at 50% at fault, you are still entitled to recovery for the 50% of damages.
That's good to know. Yeah. So even if you're in doubt, get in touch with an attorney. Martin, thanks very much for your time and your expertise, your point of view on all this. Really appreciate it. Super helpful. And I look forward to connecting in the future.
Nice seeing you, Sean.
That's it for today's episode of the Maison Law Podcast. If you want to learn more about your rights after an accident and how Martin and his team at Maison Law can help, visit their website, maisonlaw.com. As always, thanks for listening. Don't forget to leave us a thumbs up, subscribe to the show, maybe even leave a review if you found this episode helpful. Always appreciate it. I'm Sean O'Connor. Have a great day.
Great day, everyone.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.